Good afternoon. My name is Craig Cook, and I'm coming to you from the law offices of Craig L. Cook, and I want to talk to you about the legal steps after a loved one dies without a will in Arkansas, and you can also say Oklahoma. So what I basically want to talk to you about there is, what do you do if someone does die without a will and they don't have any type of what is called testate succession planning or probate planning? Well, the first thing you're going to have to do is you need to know whether you're going to have a big enough of an estate to go through what I call a full-fledged probate procedure. And what I mean by that is, do you have enough assets that warrant going through a probate procedure? More likely than not, if you have land involved, even though you're supposed to be able to do what's called a small estate affidavit, you will need to contact an attorney and go through a probate, because the title companies don't really recognize those affidavits, and you'll cause a cloud on title in case you try to sell it. So first thing, a red herring on this, to know that you need to probably contact an attorney. If somebody dies without a will or passes away without a will, you'll need to contact an attorney because of real property involved. Now, just because you have a will doesn't mean you don't contact an attorney. The will basically tells what the person who passed away, where they want the property to. You still have to contact an attorney. But at least if you contact an attorney when a loved one dies without a will, that attorney can tell you, okay, this is the way this, what's called intestate succession is set up, this is who gets what, etc. A lot of times, people without a will comes into our office and says, hey, listen, grandpa died, or mom died, or dad died, and she had all the property and she didn't have a will. What can we do? What usually ends up happening, there's something called a family settlement agreement. And most of the time, people who are a little bit older and more mature sit down, execute a family settlement agreement, and divides out the property that way. That's where you don't have a will. Obviously, a will tells court the wishes of the person who passed away and where they want their assets divided. But where you do not have a will, most of the time that can be worked out through a family settlement agreement, which we do at our office. So if you have a situation where a loved one passes away, there is land involved or significant other assets that can't simply be conveyed, or if you have a situation where you have assets and you cannot come to an agreement, you need to contact an attorney, then contact us also. But most of the time, if you have significant assets and the people are mature enough and can agree to it, then we can do what's called a family settlement agreement and divide that property. But if there are times that you can't do that, then people come to us and we have to litigate those matters. Either way, with a will, without a will, getting along, not getting along, contact us at Law Offices of Craig L. Cook by calling 479-783-8000 or go to our website. We practice in both Arkansas and Oklahoma. Thank you.